started looking at this, I thought to myself, well, what is a search engine? Because Google does an awful lot of things. And we say Google is a search engine. And I was not really convinced that Google was a search engine in everything it does, but it certainly is generally termed a search engine. But looking at definitions, you get a lot of different definitions of search engines. Some of them, as you will see, are really quite broad. The software used to retrieve information from a database or from the internet, and which may include certain search features. Or you can get really quite narrow definitions. A website that employs bots to search the web. Search engines take the information and use it to create a searchable index of the internet. So I think looking at the various definitions that you can find of search engines, I think there are some elements that sort of do come out. Some suggest that a search engine will search only content that's available on the internet, only perhaps on public servers. But of course, search engines also at times search information that has restricted access. And we all know about, sort of some of the search engines that you can have in things like Westlaw and Lexis. And some of them do search content in offline databases as well, local networks and local computers. Some search engines, you have the index, which is created automatically by a robot or a web crawler. Others might have an index database that is actually fed or edited manually. And some of the definitions suggest that the term search engine only really covers engines that are remotely accessible. Others suggest that it does actually cover search engines which are available locally. Now, why does it matter? If you're looking at intellectual property strategies and intellectual property litigation, why does it matter? And I think it probably does, actually. Because there may be different legal implications, even though the search may look similar from the perspective of the user. And one example, I think, is Google Book Search, and I'll talk a little bit more about Google Book Search in a minute. But Google Book Search, of course, searches information that's at least partly not publicly available on the internet. And there isn't a web crawler or a robot that regularly searches dynamic information. And instead, what you get with Google Book Search is books being selected on an individual basis by people, and then they're scanned, and then little snippets are made available to the user. So the question is then, should this sort of thing make a difference for liability? And what are we actually looking at? Are we actually looking at narrowly defined technology somewhere? Or are we looking at a more broadly defined business model that uses search engine technology? There's two elements to the Google Book Search. One is the Google Books Partner Program, and this is based on agreement between Google and the publishers. And so there are no copyright issues that are actually brought up there. The other one is the Google Books Library Project, and this is the one where Google is entering into agreements with libraries in order to scan collections, but there is no agreement with the publishers. So this is where the copyright issues have become important. So in the Google Books Library Project, what Google has been doing is to scan and save a complete copy of the book, but the users only see a few lines of the text. And when they search, they can't get more than 3 results each time they search. And of course, Google has been threatened with being sued. And so this has caused a change in their business strategy. They announced their project in December 2004. And then, of course, come the objections from the publishers. So they stopped scanning to give the publishers time to opt out. And then from August 2006, the public domain books become available and downloadable. So, yes, Google has been sued in a number of different jurisdictions. In the United States, 2 cases are currently underway against Google, one by the authors, class action on behalf of authors, and the other one by the Association of American Publishers. Now, these lawsuits are pending, so we don't know yet what they're going to say, but of course they're based on, or Google's arguing, US fair use. Another case in Germany, which I thought was really very interesting, was brought by a German publisher against Google, but was actually withdrawn earlier this year when the court indicated that the mere presentation of snippets, remember the 3 snippets per search that was shown by Google, was unlikely to infringe German copyright law. And further, of course, German copyright law didn't actually apply to the scanning of the books in the United States. Or it was unlikely. Of course, this case was withdrawn, so this was just where it was indicated that the petition was unlikely to succeed. And a case has been brought in France, where publishing companies and authors have joined together to sue Google. In France. One of the interesting things, I think, that has come up there, showing again our differences between laws that Google has to deal with, is that one of the things they've been, the authors and publishers have been upset about is that the way the snippets are actually presented, because it looks as if it's on a piece of paper that's torn out of a book. So the current impact of threats and litigation against Google in this arena, it has a big impact on what can be found and how the research results are actually presented. So where a publisher is not part of the partner program, you only get your very small snippets that the user can actually see. Fewer books are searchable. You do have the opt-out option, which may not be there if there were no legal concerns about whether it was lawful or not. Where the libraries do agree, there tends to be an emphasis on books that are in the public domain, or at least books that are out of print. If US fair use is ultimately successful in shielding Google from liability in the US, then Google, I think, is likely to continue carrying out its activities there, which does beg the question as to whether obviously, whether English language books will be concentrated on, and there will be fewer books in other languages. If your fair use defence does not succeed, fewer books may be searchable, maybe publishers not willing to enter into an agreement. There may have to be sharing of revenues between Google and the publishers. Your books may, of course, be better searchable, and you may get better returns. There may, however, be a cost to the consumer, and one of the things that we've been talking about today is at the moment, Google to the end user is free. If all these litigation, if Google loses in all this litigation, one wonders if everything is going to continue to be free to the user. And Google may also move on to other forms of aggregation. It might be that the book strategy is just too costly. And one of the things that was raised today, I don't know whether you've seen it, but Google now has a patent aggregation sort of facility. If you go to google.com patents, they've made available patents from the USPTO, from the US Patents Office, and I hope in due course that might be joined by patent searches available from other jurisdictions as well. We've had a case recently in the European Court of Justice, SGAG against Raphael. This was actually to do with the provision of televisions and television programmes within hotels. My question is whether it may be relevant to internet activities, particularly under the heading of communication to the public, because the ECJ did have something to say about this term, communication to the public, and I think we may well see this coming into Google activities in due course. We also see Google suffering a good deal of litigation in the realms of trademarks and AdWords. Google, of course, sells AdWords. 99% of their revenues come from advertising on Google websites and Google network sites. If you look at what Google is trying to do when they say this ranking system rewards well-targeted, relevant ads, and I wondered whether, actually, if you look at this in a more holistic approach, whether maybe the strategy of trademark owners and Google, maybe they're actually working towards the same goal at the end of the day. There has, needless to say, been litigation against Google in relation to these AdWords. There's been a number of cases in Germany. The question in Germany tends to be, is the use by Google a trademark use? And at the moment, you seem to get 50% of cases saying yes, it is, and 50% of cases saying no, it isn't. So we're not sure whether it's trademark use or not. On this point, there's two cases currently before the ECJ which are looking at trademark use. They're not directly in point, they're not dealing with AdWord use, but they may well tell us something about more broadly about what is use as a trademark, and therefore have something to say about this area as well. Google has been sued in France in relation to its AdWords strategy, and you can see a very interesting moulding of Google's business strategy in France in response to some of the litigation. Google started off by saying it had safe harbour protection under the e-commerce directive. French court said no. The court said that Google must be able to prohibit the use of trademarks as AdWords. So Google's response to that was to say to the people who were picking up the AdWords, look, you're responsible, but okay, we'll move it. If the trademark owner comes to us and says it's a problem, then we will not let you use it as an AdWord. That, unfortunately, has not been enough for the French courts as yet. The French courts have said that Google would be liable if it did not put in place a tool to allow buyers to have the information on the rights related to the word. In other words, I think to enable somebody who wanted to buy an AdWord to actually search and find out whether it was a trademark or not. That's what I took that to mean, which made me wonder whether Google would move into a new www.google.com/trademarks. And it may also be in due course that Google's strategy in France may be shaped by what turns out to be the law on what is used as a trademark. So at the end of the day, if you're asking yourself, well, is Google a free rider or a fair innovator? Well, the jury's out. There's so many cases, a number of which conflict from different jurisdictions around Europe. That the law is not clear. It's not clear for Google. It's not clear for the trademark owners. It's not really clear for the copyright owners either. But I do ask, to what extent should innovative business models exploiting advances in technology be supported? Who wins and who loses? And you can ask yourself, well, does the right holder really win if Google's strategy infringes at the end of the day? Conversely, you can ask, well, does Google win if its strategy does not infringe? So where is the balance here? And ultimately, well, what about the consumer and user? So another question, well, should high-tech companies actually just be left to play between laws in different jurisdictions? Or should there be some sort of support at an international level, some sort of safe harbour provision? But here I think it takes you right back to asking, well, what is it that you're actually trying to protect or encourage? Is it a search engine? Is it a business model? What is it? Another question, to what extent might you see competition develop between regulatory authorities? If fair use shields Google in the United States, might other countries want to support that type of innovative activities within their shores as well? Might jurisdictions be willing to say the use of AdWords is a non-trademark use and therefore encourage these types of business models as well? And ultimately, I think, to what extent will advances in technology enable the ring fencing of jurisdictions? We've talked today about certain jurisdictions, you can get different search results in different jurisdictions, and there certainly is capability of cutting out jurisdictions. And I just question whether, if a particular jurisdiction becomes very problematic for search engines to operate within, whether they maybe just ring fence that jurisdiction and come out of it. And then, who's the poorer at the end of the day? Thank you.
There's a vision out there, and the vision out there is that we should have something like a digital version of the ancient library of Alexandria. And this is, of course, a very powerful vision because probably nobody would really object that it's a worthwhile goal of having basically all the information that was produced by man in a digital format and have it searchable. And examples of this vision include, of course, the Google Book Search program, Google News for news, and to some extent even peer-to-peer file sharing, where the attractive feature is that basically all the music that is available in different formats can be searched in a peer-to-peer system. This, of course, has raised tensions with copyright law, and Charlotte has already commented on this quite a lot, so I'll keep it short. In the United States, there's always a discussion about the fair use doctrine applies to these kinds of concepts. In the European context, we are mostly talking about more specific exceptions to copyright law. In Germany, there has been some litigation in connection with Google Book Search, but it didn't lead to an injunction at the end. In Belgium, there has been a case about Google News, where Google was basically forced to exclude certain news articles from Belgium Google News search. And one of the proposals that is out there is to basically solve these tensions by moving to an opt-out regime, what I've just described. And some of the arguments in favor of such an opt-out regime are based on transaction costs. So in the context of Google Book Search, the kind of argument that that lies beneath is that for Google to create such a comprehensive book search, it would basically impossible to get all the necessary licenses from copyright holders, and an opt-out regime would basically solve the transaction cost problem, because the copyright owners for them it would be very easy to have the necessary information and also to contact Google and say, well, we want to have our works as part of Google Book Search or not. So the underlying argument is that opt-out is one of several possibilities to solve transaction cost problems. There's a second line of arguments which basically tries to apply a theory from contract law and contract theory called penalty defaults to Google Book Search, where the idea is that basically you can use opt-out regimes as tools to force the revelation of information which is only available to one party in such transactions. And I won't comment on that. It's questionable to what extent this can actually be transferred, this concept, to the Google context. So this seems like a very powerful argument for having an opt-out regime, because it seems to enable some version of a digital library of Alexandria. What I want to do in the remaining minutes is to point to some of the problems this paradigm has in contexts such as Google, but also in other contexts. So first, just to mention, I think there's one no problem, or there's one issue which is not a problem, which is sometimes raised in these areas, that by moving to an opt-out regime, you basically weaken property rights for copyright holders, and that's a bad thing on its own. I think the more one analyzes copyright protection from a law and economics issue, the more it becomes clear that one is basically just talking about different entitlement structures, and whether a weakening of property rights is a good or a bad thing cannot be said in abstract, and so it can be actually something that is a good from a general perspective. I think from a more abstract perspective, it is debatable if one wants to have a digital library of Alexandria, who actually should provide the library. So the Californian answer is, of course, that it should be Google, a private company that is able to achieve this. The European answer to this has been, well, of course, it should be the state. And France and Germany stated that they would actually try to create something like a competing vision and version of this library. And as some of these projects, which are stated by politicians, go, nobody has really talked about this for quite some time, and it doesn't seem to be realized. The copyright holders' answer, of course, is that it should be the copyright holders who should provide such a library, and that's kind of a strong argument which could be made. But again, in reality, it seems that actually Google is the company which could achieve this, so there's a strong argument that if there's at least one institution that seems to be able to do this, that one should get rid of hurdles this institution is facing. I think on a more abstract level, copyright policy has always had a problem to deal with emerging intermediaries that have kind of unusual revenue streams. And that's what we're experiencing with Google in different contexts, in the book search context, but also with keyword advertising at the intersection of searching and trademark law, where the problem is basically that Google does not make its revenue by selling books or by selling trademarks or goods that are attached to trademarks, but that it's basically just using this content in its business model and makes its revenues through advertisement. And to analyze what this means from a copyright perspective, that you have basically an intermediary who squeezes in between other firms in the market and makes its revenues from a different source that is not normally between the firm and the market seems to be a complicated issue. And more general, what one sees in the search context increasingly is that intellectual property is used as a tool to control markets that emerge on top of the search platform. So we have had discussions about whether and to what extent intellectual property should be used as a tool to control auctions of virtual property that emerges out of these virtual worlds, and to what extent IP should be used to control this, these kind of auctions that appear on eBay and other institutions. And similar issues have been arising in areas such as the EU database protection area. I think in this whole context, it's also important to think about the use of language in these issues, which one sees in other areas of copyright discourse as well, the use of words such as piracy and so on, which have a certain connotation. And I think one sees this in this area as well. So Google has managed it to a large extent to portray itself as a don't be evil company, to be basically in the interest of users and the public at large. And if you just think as a thought experiment to basically think about these projects and replace words like Google with Microsoft, or the words like digital library with digital restriction management, I think one gets an idea that the whole discussion may play out differently if just the institution that would engage in these projects would differ. I think it's also important to look at search in a broader sense, not only to look at Google, of course, but also to look at search in other contexts. So if you think about eBay, peer-to-peer, YouTube, the domain name system, Usenet groups, these are all different ways of structuring content in a searchable environment. And if one looks at these developments, then the search discussion, I think, becomes richer. In particular, I think it's important to think about what would happen if we are moving from a kind of centralized search environment towards a more decentralized search environment, where there is basically not one company that provides the search service, but where different components of the search service are basically becoming decentralized. And that's what you're seeing in particularly in areas such as peer-to-peer, where there's a definite trend towards decentralized peer-to-peer services, but you also see this in other areas. So the boundaries of what a search engine is becomes much more blurry, and it becomes kind of hard to draw the line what a search engine is and what it's not. And just to give you an example, I think if one would think about a very decentralized environment, then the argument about an opt-out regime, for example, for issues such as Google Book Search, becomes much less convincing. So the argument in the Google Book Search context is that basically there are lots of different copyright holders out there, and there's one company who does the aggregation into the Google Book Search context, and it may be easier for the copyright holders to identify and contact this particular company, and therefore it would be nice to have an opt-out regime. If you're thinking about kind of a more symmetric environment where there's basically not one company such as Google, but there are different content aggregators, the whole argument about lowering transaction costs by moving towards an opt-out regime for copyright holders may not thrive anymore in this context. So, and to finalize, I think it's very important not to forget Switzerland. And the reason why that is so is that in lots of these discussions, which are basically policy-driven, one should not forget that there's an international dimension to copyright policy all the time, and this is issues such as the Berne Convention and TRIPS Agreement and other international treaties, where you, in particular, you have the three-step test, which to a large extent limits the ability of national copyright legislators to experiment with limitations on copyright law. And I think that is something which one should take into account when thinking about new conceptualizations of copyright law in this context. And I think sometimes this is an area where not enough attention is paid towards. So one argument So there are arguments according to which the opt-out regime under Google Book Search do not comply with the Berne Convention. And one can argue whether that's true or not, but I think it's just an important discussion to make. And if one would be of the opinion that having something like a Berne Convention is a bad thing, then of course you're starting to discuss whether something like the Berne Convention should be changed, and that's really a major, major issue. So one should be careful about these kind of arguments. Thank you very much.
I want to start with Google's mission statement. We keep talking about do no evil, but in fact their mission statement is as follows. Google's mission is to organize the world's information and make it universally accessible and useful. And it's the issue of access that has become increasingly prominent over the last few years and I think deserves a bit of attention. We talk increasingly about access, although sometimes we don't define it as such. We talk of access to the network as being absolutely essential. People having the ability to communicate and needing that access. We also talk, although not today, about net neutrality, which ties in nicely with that. The A2K movement, or access to knowledge, providing new economic opportunity and the like. Access to research, which is happening from large numbers of research funders and the like, in a push to have open access for particularly state-funded research, as well as access to heritage, in a sense public domain-related issues that help preserve our heritage. Now, we have, of course, a number of policies and have developed over the last few years a number of policies designed to promote access. Open access programs that I made reference to, connectivity programs, and even in some countries, notably the United States, proposed legislation that would actually seek to punish those countries that don't provide access to certain content. So punish those that engage in various kinds of censorship. And it seems to me that it's a little hop, skip, and a jump. It's very closely aligned between the promotion of access to the promotion of search engines. Now, it hasn't been search engines per se, but it's been intermediaries of which search engines have been very happy to occupy a similar space. In the United States, you've got things like the Communications Decency Act, which is legislation from the mid-90s, which was focused at first, in certain respects, on internet censorship, but beyond just that, also focused on questions of immunity for intermediaries. And intermediaries has been broadly defined to include not just your traditional internet service provider, but also companies like Amazon as well as Google. So where there is content posted that they host, that it's third-party content, they may not find themselves liable. There's also been some caching exceptions because, of course, Google has to cache the content to create its database. There have been exceptions made in a number of countries that seek to protect Google or any search engine for that matter. And in Canada, we briefly had a proposed provision which died when the legislation died that actually was really a Google cache provision. The Google cache provision is that nice little thing, Google Cache, where you get a 404 error. The website has disappeared, but Google has made a copy of that web page, and if you click on it, it'll display the web page. Canadian legislation, actually, it was a very badly drafted piece of legislation, or provision, but the provision, its intent was to actually immunize Google from having the act not just of copying that web page, but then also displaying it and making it available to others. So a real intent, seeing that there was a public benefit to being able to access a page that had disappeared and seeking to protect Google in that regard. And even the US DMCA exception process, which has been much criticized, has focused a little bit on this. Most recently, the Internet Archive, Brewster Kahle's project, has managed to obtain exceptions focused on preservation. And the Internet Archive is also a search engine, though we haven't talked much about it. There's also some case law designed to promote search engines as well. Thumbnail photos in the United States, as well as Google Cache in the Blake case. I think notably a very recent Canadian Supreme Court of Canada case, which has nothing to do with search engines at all. It was sort of the Canadian version of the Tassini case, a case between freelance writers on the one side, publishers on the other. And the issue of whether or not the freelance writers, particularly from, say, the 1990s, who had not agreed in their freelance contracts to have their works digitized, were entitled to compensation.